As a leader, you serve as an agent of U.S. ecology, and it's important that you create and foster a work environment that's both safe physically and emotionally for your team members. In order to do this, you must understand several key employment laws. Let's review the key laws that primarily impact your work. Wait, employment law doesn't get you excited? You'd rather be doing something else other than taking this training, right? Well, don't worry about that. We're going to focus on things you absolutely must know in order to avoid legal issues that can sink even the best supervisors. When leading team members, you must understand the key laws that impact employment in the United States. Although there are many laws, the Fair Labor Standards Act, the 1964 Civil Rights Act, the Age Discrimination in Employment Act, Veteran Status Legislation, the Americans with Disabilities Act, and the Family Medical Leave Act cover the key laws you must understand in order to successfully lead teams at U.S. Ecology. So let's explore each in greater detail. Fair Labor Standards Act. In 1938, Congress passed the Fair Labor Standards Act, or FLSA. The FLSA created minimum wage standards, updated child labor laws, and established overtime rules. As a supervisor, you need to know which of your team members are covered by the FLSA overtime provisions. The FLSA has job duty tests to determine who is exempt from overtime regulations. As a general rule, positions that are classified as executive, professional, and administrative are exempt from the FLSA overtime rules. Non-exempt positions are covered by the FLSA. Therefore, they earn overtime when working more than 40 hours a week. Every position at U.S. Ecology has been assessed to determine if it falls under the FLSA. At U.S. Ecology, the official work week is Monday through Sunday. This is set by the executive team, and it cannot be adjusted by you to avoid overtime. For example, you can't change the work week to end on Saturday in order to avoid overtime for time worked on Sunday. When non-exempt team members work more than 40 hours in a week, they earn 1.5 times their hourly wage for time worked in excess of 40 hours in a given work week. California has additional overtime regulations, and some positions may earn overtime whenever the team member works in excess of 8 hours in a given day. When the Civil Rights Act of 1964 was signed into law, it ushered in a new era of employment discrimination protections. Under the law, all people are guaranteed protection against adverse employment decisions such as hiring, promotion, and/or termination based on 5 key attributes: race, religion, sex, color, and natural origin. Employers cannot factor these 5 attributes into employment decisions. Court decisions in the subsequent years have expanded and clarified these protections to include pregnancy, for example. Many states have extended anti-discrimination protections to sexual orientation. However, this is not a federal protection at this time. In 1967, the Age Discrimination in Employment Act, or the ADEA, was signed into law. The ADEA extended legal protections against adverse employment actions based on age. Although the Act specifically protects those 40 years of age and above, it is best practice and USC policy to not use age as a factor when determining employment decisions. The Vietnam-era Veterans Readjustment Assistance Act of 1974, VEVRA, and the Uniformed Services Employment and Reemployment Rights Act of 1994, USCRRA, protect military veterans from workplace discrimination based on their veteran status. Originally established to protect Vietnam veterans, the law has regularly updated to protect today's veterans. U.S. Ecology supports military veterans and welcomes them to join the USC team. The Americans with Disability Act of 1990, or ADA, extended legal protections to those who have or are considered to have disabilities. This law addresses building and workplace accessibility, as well as worker rights and protections. The law protects qualified individuals with disabilities in several areas, including job application procedures, hiring, firing, advancement, compensation, and job training. The law forces employers to ask an important question. Can the person perform the essential functions of a given job with or without reasonable accommodation? If an employer can reasonably accommodate a given disability with such things as assisted listening devices, rearranging a workspace, or obtaining other accessible technologies at a reasonable expense, then the employer must consider the applicant or team member to be fully capable of performing a given job. U.S. Ecology has trained HR staff who can assist you when you encounter an ADA need. Be sure to contact them. In 1993, the Family Medical Leave Act, FEMLA, was signed into law. The FEMLA entitles eligible team members to take unpaid, job-protected leave for specific family and medical reasons with continuation of group health insurance coverage under the same terms and conditions as if the employee had not taken leave. To be eligible, team members must have worked for U.S. Ecology for 12 months and worked a minimum of 1,250 hours. If a team member meets these requirements, they are eligible for 12 work weeks of leave in a 12-month period. For a serious health condition that makes the team members unable to perform the essential functions of his or her job, the birth of a child and to care for the newborn child within 1 year of birth, the placement with the team member of a child for adoption or foster care and to care for the newly placed child within 1 year of placement, to care for the employee's spouse, child, or parent who has a serious health condition, or military family leave provides up to 26 weeks leave for a covered active duty spouse, son, daughter, or parent. So now that we have quickly reviewed the key laws that impact the life of a supervisor, it is critical to remember that what you think makes reality. If you think a team member is Native American and treat them differently based on this assumption, it doesn't matter if they are Native American or not. They are protected against racial discrimination. The same goes for the ADA. If you assume someone has a disability and you treat them adversely because of your assumption, it doesn't matter if they have the disability or not. They are protected under the law. Finally, ignorance is no protection. You are responsible to adhere to state and federal labor laws, regardless of knowing them or not, so it is critical you become familiar with them to ensure you manage your teams effectively.
Well, hello there. I bet you thought you were done. Not quite yet. Click on the link below to sign up for the virtual session. That's right. You must click on the link below to fill out a survey to let us know that you've completed this training and be signed up for the virtual session.